Good day, I'm Advocate Dismissal, Legal Manager at Strata-g Labour Solutions. Employers often contact us in order to find out whether or not employees have any right of recourse after having been dismissed. Well, the reality is that employees do have the right to challenge their dismissals in circumstances where they feel that it was either not effected for a fair reason or in accordance with a fair process. Employees have the right to refer their dispute to the CCMA within 30 days from the date of their dismissal. Once the matter has been referred to the CCMA will normally set the matter down for a con-op process. Con-op simply means that both conciliation and arbitration will take place on the same day. Both the employer and the employee, however, do have the right to object to arbitration immediately preceding after conciliation. This is often done in circumstances where witnesses are unavailable to attend the arbitration proceedings, or in circumstances where parties would much rather attempt to resolve the matter through the process of conciliation. There is no need to prepare extensively for an arbitration dispute if parties are able to resolve the matter through conciliation. Therefore, it's always in the best interest of both employers and employees to rather object to the con-op process and utilize the conciliation process itself as a means to try and resolve their dispute. Now, the means by which a dispute regarding an alleged unfair dismissal can be resolved may vary depending on what it is that the employee seeks. The CCMA only has jurisdiction to award 3 types of relief to an employee. The first form of relief is compensation. Now, many employees think that they can go to the CCMA and claim millions. The reality is that the maximum amount of compensation that can be awarded to an employee is 12 months. And the likelihood of receiving such an award is dependent on various factors. It is therefore incumbent upon parties to be reasonable when they are discussing possible settlements, taking into account length of service, the misconduct for which the employee had been dismissed, whether or not procedure had been followed, progressive and corrective discipline had been applied, etc. The other form of relief that parties can claim are either re-employment or reinstatement. Now, many employers get confused between the two. Reinstatement effectively means that the employee gets reinstated back into his or her position as if he or she had never been dismissed. Re-employment, on the other hand, means that the employee is employed afresh. It can be a different role, different terms and conditions, it doesn't matter. It's as if the employee had never been previously employed by the employer. Whether or not parties are able to reach an agreement obviously depends on both parties' willingness to resolve the dispute. If parties are unable to conclude an amicable agreement or settlement agreement during conciliation, it will then be incumbent upon the employee to refer the matter to arbitration. In circumstances where no notice of objection had been filed against the con-op process, arbitration will immediately precede the conciliation process. It is therefore important for employers to know and understand the rights of employees after having been dismissed and to familiarize themselves with the process. Remember, during the process of conciliation, no legal representation is permitted, and therefore it's important to seek proper advice beforehand. Thank you.